This video examines Do LLMs Fabricate Legal Citations, a bilingual benchmark on Saudi data protection law and the GDPR by Noura Suliman Alrajeh. The purpose of this video is academic research and educational study.
Welcome to this explainer. Today, we're going to treat this like a graduate-level seminar. We're going to step up to the chalkboard and meticulously reconstruct the author's analytical framework, step by step. We'll be looking at the core research question, some key concepts, the methodology, the massive jurisdiction gap in the findings, real-world applications, and finally, our key takeaways. All right, let's jump right in.
Section 1. The Research Question, Investigating LLM Legal Hallucinations. Okay, let's map out the logical progression here. Imagine drawing this out on a board. On the left side, we have our core problem, and that problem is the rapidly growing reliance on large language models, LLMs, for regulatory compliance. Now think about it. A wrong statutory citation from an AI can silently propagate right into serious legal advice and policy decisions. It's a completely silent danger. So, drawing an arrow from that, we arrive at our specific research question. When asked which article of a data protection law governs a given matter, do freely accessible LLMs actually answer correctly? Do they abstain honestly? Or do they just fabricate? To figure this out, the author proposed a very specific investigation, which is a cross-jurisdictional bilingual test. They compared performance on the well-known European GDPR directly against the Saudi Personal Data Protection Law, or the PDPL.
Moving to Section 2, Key Concepts and Context. Before we look at the data, we really need to define the terms. Let's look at this concept of sycophancy. In plain language, this is basically when an AI model acts like a total yes man. It's when the AI uncritically accepts and validates a completely false premise that's embedded right within a user's prompt. So for example, if you were to ask a loaded question like, hey, does Article 20 of the GDPR govern breach notification? Even though Article 20 actually governs data portability, a sycophantic AI will just confidently agree with you. It effectively confirms a fabricated legal article. And that's not just a blind spot in its knowledge, it's the active validation of a falsehood.
To really understand why this research was so necessary, we have to look at the existing literature. The prevailing literature is heavily focused on English language, US or Eurocentric law, like the GDPR. And why? Because those texts have massive representation on the open web. But the author identified a massive gap here. Recently enacted regional laws, like the Saudi PDPL, whose authoritative texts are in Arabic, remain largely untested. They're a giant blind spot in AI trustworthiness. And if AI models are being widely deployed but completely fail on non-Western legal frameworks, well, we've got a newly identified equity problem in our digital ecosystems.
Section 3. The benchmark methodology, or exactly how we're testing these models.
The author built this incredibly rigorous 120-question bilingual testing framework. That's 60 questions per law, posed in both Arabic and English. Let's break that down. First, we have direct retrieval probes. This is testing closed-book accuracy. Then, we have verification probes, which test for that sycophancy we just talked about. But honestly, the most ingenious part of this whole methodology, the trap questions. These are completely unanswerable by design. The only correct answer is for the AI to explicitly state that no such article exists. The author designed these traps to exploit known failure modes, like asking about Article 32 of the PDPL, which was actually repealed, or asking about a deadline that technically exists in the implementing regulations, but not in the law itself. It's a brutal but brilliant test to see if a model actually knows what it doesn't know.
For the test, the evaluated models were Gemini 2.5 Flash, GPT OSS 120B, and Nemertron 3 Super 120B. Now, why these three specifically? Well, the author intentionally selected freely accessible open-weight models. That's not arbitrary at all. It reflects the exact deployment reality on the ground. Cost-sensitive organizations, startups, and individual users in the region predominantly rely on free tiers, not premium enterprise APIs. Plus, open-weight models can be deployed locally, which perfectly matches the really strict data sovereignty constraints you often see in public sector settings.
All right, Section 4, Findings. The jurisdiction gap. This is where the primary hypothesis gets put to the test, and the data really speaks for itself. Okay, the contrast in this data is absolutely dramatic. When tested on direct retrieval correctness for the European GDPR, the models performed near perfectly. We're talking 100%, 94%, and 100%. But watch what happens when those exact same models are tested on the Saudi PDPL.
The accuracy just collapses to 13%, 7%, and 40%. The models didn't just abstain and say they didn't know. They overwhelmingly answered with specific, confident, and entirely wrong article numbers. They literally fabricated the citations. Now, you might immediately assume, oh, this is just a language issue, it's a weakness in Arabic NLP, but the author actually proved otherwise. Let me read this critical insight directly from the paper. The reliability gap tracks the jurisdiction of the law, not the language of the query. Models fabricate PDPL citations even when asked in English. This is a profound finding. The root cause here is the training data representation, not the language itself, meaning answering in a user's preferred language offers zero protection if the model simply lacks the underlying jurisdictional knowledge. And remember those trap questions we discussed earlier? A staggering 67% fabrication rate occurred on the traps specifically designed to confuse the statute with its implementing regulations. When a deadline lived in the regulations, the models confidently and completely incorrectly attached it to an article in the main statute. This proves that current LLMs are systematically blind to normative legal hierarchies. They just cannot distinguish between the primary law and the secondary regulations that actually implement it. And here is where it gets genuinely dangerous. 0.91. That is the mean self-reported confidence score of the fabricated citations. Over 91% of all these fabrications were asserted with a confidence score of 0.8 or higher. It's exactly like a student confidently bluffing their way for a final exam when they have zero actual knowledge. This completely exposes the danger of model self-assessment. Internal confidence scores are utterly useless as a safeguard here. If you're relying on a model's confidence to determine if a legal citation is real, the vast majority of those fabrications are going to slip right past you. Section 5. Real-world applications and the implications for compliance. So, what do these error rates actually mean for a compliance officer on the ground? If confidence scores don't work, what on earth does? Well, the author's proposed solution is clear. We have to implement verbatim verification guardrails. Basically, before any LLM-generated citation is ever displayed to a user, it has to undergo a hard reference check against a gold index of the authoritative text. You simply cannot trust fluent AI outputs in a legal context without independent, programmatic verification. It's just too risky. Which brings us to Section 6, Conclusion and Takeaways. As we wrap up, let's initiate a complete reconstruction of the author's final chain of reasoning. Watch how beautifully this argument builds. The author started with a core question about citation fidelity. To answer it, she developed a really rigorous bilingual benchmark method. The evidence generated from that revealed a massive performance gap between the GDPR and the PDPL. By analyzing this data, she proved the gap was driven by jurisdiction, not just query language. And this entire analysis leads directly to the final, justified position. Strict verbatim verification is an absolute necessity. The genuinely new and important scholarly contribution made by this paper is establishing the very first bilingual benchmark that actually proves a jurisdictional equity gap in AI legal reliability for Arabic statutory law. It finally moves the conversation beyond just English-centric evaluations, which is huge. Of course, as with any academic lecture, we have to acknowledge the boundaries of the study. The limitations here include that it was a closed-book citation test, it evaluated free-tier models, though as we discussed, we know exactly why that was a deliberate and practical choice, and it relied on a single annotator gold index. As for future research, scholars and engineers really must investigate how to encode normative hierarchies into retrieval augmentation. Basically, we have to get these models to stop confusing primary statutes with secondary regulations. So what should you take away from all this? Here are 3 highly practical lessons for you. Number 1, jurisdiction drives AI reliability far more than query language. Number 2, high model confidence is a terrible proxy for legal accuracy. These models will hallucinate with total certainty. And number 3, strict verbatim verification is absolutely mandatory for any organizational compliance screening that uses LLMs. I want to end today's explainer with a provocative thought based directly on the author's work. If AI reliability degrades precisely where users have the fewest alternative resources, how can we ensure equitable digital trust across all global jurisdictions? It's a massive, massive challenge for the future of AI. Thank you so much for joining me in breaking down this fascinating research.